So good morning, everyone. Thanks for joining us for today's webinar, Unlocking Justice Alternatives, Restorative Justice Conferencing with Adults in the Criminal Justice System. My name's Penny Sullivan. I'm a Capacity Building Lead at Community Legal Centres, Queensland. First, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. We pay deepest respect to elders past, present and emerging. As this webinar is being viewed by people across Queensland and around Australia, we also pay respect to the traditional owners throughout the country. We recognise Aboriginal and Torres Strait Islander peoples as the traditional custodians of the land in Australia and their continuing connection to land, water and culture. We acknowledge the stories, traditions and living cultures of Aboriginal and Torres Strait Islander peoples. We commit to fostering a culture of learning from and working with First Nations peoples in the spirit of reconciliation and access to justice. We extend a very warm welcome to any First Nations peoples joining us today. So I'm very pleased to now welcome Crocket and Emma Yates from Adult Restorative Justice Conferencing in the Department of Justice, who are going to lead us through the details of Adult Restorative Justice Conferencing, including an overview of the background and history of this mode of addressing the harm caused by crime, where it fits in the overall structure of criminal justice and dispute resolution and conferencing processes. I'll let Casey and Emma introduce themselves when I hand over in a moment. Before I do that though, just some quick housekeeping. Today's webinar is being recorded and later today or tomorrow I'll send the link for that recording along with a copy of the PowerPoint slides. I have also made the PowerPoint available in the handout section of the GoToWebinar control panel. We will be undertaking some polls through this webinar and sharing those results live. We do also encourage you to ask questions. Please type your question into the question box on the control panel and I'll read your question out. We'll hold questions to the end of the session, but you're welcome to type them in as you think of them. That's it from me for now. I'm going to hand over to Casey and Emma and we'll speak to you again later in the session. Thanks so much, Casey and Emma.
Thanks, Penny. Good morning, everybody. Hello, my name is Casey Crocket. I'm a senior convener from Adult Restorative Justice Conferencing, and I'm here with my lovely colleague,
Emma Yates, and I'm also one of the conveners at Adult Restorative Justice Conferencing. And we're very grateful to have this opportunity to present this webinar today and looking forward to engaging with you through questions in the chat. So I've got this slide up already. So this is what we're going to be touching on today. What is restorative justice, particularly adult restorative justice conferencing? What's the history? How did this evolve in Queensland and where it fits within the overall structure of both the criminal justice and dispute resolution systems? How does it benefit people to participate in this process? What is the process? How can people access adult restorative justice conferencing? Looking at how we consider risk and safety, how do we assess suitability for conferencing, and also what kinds of outcomes are possible.
So first up, we want to see what you know about restorative justice. So Penny's going to assist us with some questions to test your knowledge of restorative justice.
Great, thanks Casey. So I'll just launch these polls one by one across these questions and all we ask is you just select the answer and then we'll wait probably about 30 seconds and we'll get each of those results in turn. So we're going to start with the first one, which that adult restorative justice is new to Queensland. So
it's a true or false question, is that right?
Yes, that's correct. So that's launched for people now. So adult restorative justice is new to Queensland. Is that true or false? If you could just be please popping your responses in. We have just probably about another 10 seconds or so for people to pop that in. So there we go. We've got about a third of people have voted. 5 more seconds. Great. Thank you. Now, just hopefully I'll get this right. Let me see. So I need to share those poll results. There you go, Casey and Emma. So 93% of people identify that as false.
Oh,
7%
that's
say
pretty
it's
good.
True. Okay.
And we'll go on to our next question. Restorative justice is mediation, true or false?
There we go. So that one's up. People can be voting. We'll give you about 20 seconds, I guess, for that. I think people are getting the hang of this now, so we've got 5 more seconds or so. Pop your responses in. Okay, there we go. Right, so we're going to share those results. So we've got 81% say false, 19% say true.
Oh, very interesting. We might have a clued in audience here. We'll go on to the next question, which is restorative justice is only suitable for low-level crimes. So we're talking about willful damage, assaults, not serious crimes. True or false?
So we're away. We've got about 28% of people have voted, so we'll give another 10 seconds or so for people to get their responses in. And just ticking through. Okay, that looks good. Let's get those results. And we're seeing 25% of people say that's true, 75% say it's false.
Ooh, that's an interesting response. All right, on to our next one. Restorative justice is available across Queensland. Is that still one of our questions, Penny?
Yes, it is. That's the next one. Yep.
All right, true or false? Available across Queensland.
Here we go. People are getting the hang of this now. We're getting quite strong responses quickly, so that's fantastic. We've got about 42% of people voted. That looks pretty good. Another few seconds, get your responses in. Great. Okay, we'll share those results. So we've got 82% of people say that's true and 18% say it's false.
Oh, interesting. I like it. Okay. On to our next question. Restorative justice is available at any point in the justice system. So we're talking pre-charge, post-charge, pre-sentence, post-sentence, any point in the justice system.
Great. So we've got probably another 10 or 15 seconds for people to get their responses in again. We're up around, I've got about
this one
voted.
I think we're going to get some interesting responses.
Yeah, it's looking much closer, I have to say, this time. It's perhaps not as clear. All right, so another few seconds. Great. All right, we'll close that and we'll share those results. So we've got 46% say true, 54% say false.
Ooh, this is fascinating. All right, our last one, Penny, is victims and offenders are required to meet in a restorative justice conference. True or false?
Great. All right, we've got voting is happening. It's a little closer as well, this one, so not as clear cut probably. Some of the others. We've got nearly half our people have voted already, so we'll do another few seconds, get those responses up. Okay, great. Thanks, everyone. We'll close that and share those results. We've got 26% say true, 74% say false.
All right. Thank you, Penny. I think we have a pretty clued in audience here with some knowledge of restorative justice, but there might be a few things about adult restorative justice conferencing that we're going to share with you today that might surprise you in relation to those questions. And just before we move on, I just want to note that you might have heard us using some different language already today. So you can see on the slide, we've got victims and offenders. You might hear us say person harmed, person responsible, or we're part of the justice system, so we often say complainant and defendant. So we move fluidly throughout these terms depending on where we are, but in a restorative justice setting, we would talk about a person harmed as a victim and a person responsible as a defendant. So we're going to be using that language today as we go through the presentation.
Thanks, Katie. So just to kick us off, thinking a bit more about what is restorative justice and what does that look like in adult restorative justice conferencing, we're going to share with you a video. So this does go for about 7 minutes. It's Roman and Carmen's restorative justice experience. So this couple participated in RJ through our process, and this clip features them and the person who harmed them, as well as some of our workers and colleagues talking a bit more about the process.
Okay, well, hopefully you got to see and read a little bit of the video about restorative justice conferencing, and you may have had some of your questions answered from our first slide about what is restorative justice conferencing and where it is in Queensland and the justice system. But we're going to go through all of those things a bit more in our presentation to help you understand about restorative justice and what it can do for the people who might be coming in to see you at the community legal centers. So a bit about the history. Most of you did know that restorative justice has been in Queensland for a very long time. So it started back in 1992 in the dispute resolution branch for both the youth and adults in post-sentence referrals. That was the Crime and Reparation Project, and it was called Victim Offender Mediation back then. Eventually, the youth program was expanded, and that later became Restorative Justice Conferencing in the Department of Youth Justice, and it split from the dispute resolution branch in about 2000. And the adult program stayed with the dispute resolution branch and continued there as a very small program and was called Justice Mediation. So it used that mediation title to fit within the purview of dispute resolution branch. So it continued for quite a while in just a few locations across the state. In 2007, it expanded, it got a little bit bigger to go to the Gold Coast, and it was only for first-time offenders and low-level crimes at that time. But then in 2017, we started a big review of our program and what we offered, because we noticed that our referrers were sending us more complex and more serious cases. We also went out and looked at best practice, what was happening in restorative justice across Australia, across the world, and we found that restorative justice had changed and the research around it had changed. So we changed our name to align with that, and we became Adult Restorative Justice Conferencing, still a part of the dispute resolution branch, and we started accepting all types of referrals for all types of harm. So we kept the adult part to differentiate us from restorative justice in youth, and we changed it to restorative justice conferencing to show that it's not mediation. Restorative justice and mediation are quite different. We still are a part of the dispute resolution branch, which has a few different services that it offers. So adult restorative justice conferencing, court-ordered child protection conferencing, mediation, and training in dispute resolution. So I'm just going to click on this link to the dispute resolution branch so you can see a bit more about who we are and what we do. I think it might be worth pointing out community mediations is probably a particularly interesting point for Community Legal Centres Queensland. So that's for civil disputes, including neighbourhood disputes, workplace disputes, commercial, multi-party disputes, First Nation community disputes, and court-referred matters like peace and good behaviour orders. We don't provide family dispute resolution because we can't provide the certificate needed for the family court process, but we can assist with property settlements or other family disputes that do not involve children. So that's through the mediation part of the dispute resolution branch. And we also offer training in mediation if you're looking to upskill and come over to the mediation side. So just a bit about the history of restorative justice and where we sit within the justice system.
Thanks, Katie. So This slide just kind of touches on some of the things that really have already been talked about in the Roman and Carmen video. Just want to highlight, I guess, the idea that within the criminal justice system, the focus is really on the rules and the law. You know, has the person committed a crime in accordance with what the law says? If they're guilty, then how should they be punished? So RJ takes a very different approach of looking at what's the harm that's been done, who are the people who've been affected, and what's needed to make things right. It's very much designed around the needs and wishes of the person harmed. What would meaningful justice look like to that person? And it definitely still requires the person responsible to be accountable. So we're talking about harm that's been done, about acknowledging wrongdoing and being genuinely accountable for what you've done. Voluntariness is really important, and we will touch on this a bit more. So it's really important that, for example, if the defendant asks police to do a referral, then they would have to talk, the police that is, would have to talk to the victim first and get their consent to the referral being made to us. And people can pull out at any stage of the process if they decide it's not meeting their needs. We're also bound by confidentiality. So we keep things confidential, and we get very specific permission from people throughout the process if there's anything that we need to communicate to the other person. It's also privileged, and I'm sure as lawyers, you all understand what that means. And those things are a really important part of restorative justice, because we're seeking to create a space where people can feel safe. It's a non-judgmental process, and it's a space that encourages truth-telling.
And as I mentioned, we're under the dispute resolution branch. So we work under the dispute resolution branch legislation, which is the Dispute Resolution Centers Act of 1990. That gives us the confidential and privilege aspect of our work. So restorative justice is a lot of things, but I just wanted to highlight a few misconceptions about what it is and what it is not. So a lot of people think, oh, you can get money from restorative justice. Just go here and they'll give you money. It's not a quick way to get money. We can only really facilitate restitution and compensation, and we'll talk a little bit more about that. The biggest thing that we get is people thinking it's a soft option. It's an easy way to get out of charges. As you heard from the video, it's not an easy option. At no point in the criminal justice system does a defendant or an offender have to actually face the person that they've harmed. So it's very challenging for them to actually sit down and look at the person that they've harmed and talk about what they've done. So it can be extremely challenging. We're not negotiating responsibility for harm or negotiating a settlement. So this is where we differ from mediation. We're not dealing with two people in conflict and trying to negotiate out terms. We're dealing with someone who's been harmed and the person who's harmed them. So it's not the same balance of power in the room. So we're not also helping people negotiate their way out of a crime. We're helping people take responsibility and repair the harm. It's not suitable for just minor offenses. We've actually found, and the research has shown us, the greater the harm, the greater potential for positive impact and satisfaction with the process. So you heard earlier in our program, we were just for first-time offenders, just for low-level crimes. That has changed, and we accept all different types of crimes, and we found that we can be extremely impactful when there is a serious amount of harm. We're not there to reach a compromise just to make the charge go away. We do work on a diversionary basis, and that is how the justice system is currently using us, that the referrals that we received are diversionary. So if we are able to work towards a restorative outcome plan that meets the needs of the parties and everybody completes what they say they're going to do, the charges are dropped as a result of that. But that's a decision for our referrers, such as police and the DPP. We're also not just getting people in a room to say sorry. We are checking their level of accountability, and they have to be genuine to go through this process. If they're not actually genuinely engaging with us, it's not appropriate for restorative justice.
Thanks, Casey. So I think you've already heard there are some significant benefits for a person harmed in this process. I might just let you read that slide. One of the things about restorative justice and some of what's on this slide is it really shows how closely aligned restorative justice is with trauma recovery. So we know that, you know, what's happened to a person harmed by crime usually has taken away their choice and their control. And this process gives back choice and control. The person doesn't have to retell the story if that's going to re-traumatize them. But sometimes people really want to tell the story. They want to hold the person who's harmed them accountable to their experience. Another thing we hear a lot is that what happened just doesn't make sense. That can be one of the hardest things. So having the opportunity to hear from the person responsible what led to their behaviour, both people getting to hear from each other, can actually help both to start to make sense of what happened, and that can lead to closure, or can be an important part of closure. For the person responsible, there are also significant benefits. Casey's mentioned the diversionary aspect. Not having a criminal conviction can obviously be very significant in terms of future work and other prospects. When we talk about restorative justice, we talk about making things right, and certainly for me, engaging with people responsible, it's so clear that it's an opportunity not only to make things right with or for the other person, but also to make things right in and with yourself. So, you know, taking responsibility, apologising, can be a significant part of making things right in yourself, and kind of for that person also recovering in terms of what they've done. They get a significant involvement in determining the outcomes, and we then know that we have a very high compliance rate then with the agreed outcomes. RJ is a less stigmatising process than the court system because we focus on the person's behaviour rather than on the person. And also that opportunity to reflect on your actions and what might have led to them and what might be the root causes, and then often outcomes are linked to that in terms of taking steps to try and make sure that the person doesn't reoffend, and that's obviously of benefit to the person responsible as well.
So thanks, Emma. The benefits for the community. You might not think, oh, hey, there's a justice process out there that can benefit the community. But restorative justice does have a benefit for the community. First of all, it allows the people who've been impacted to be involved in the response to the crime. So that is actually a very powerful thing. And it can give them a better understanding of the causes of crime. Why does this type of thing happen? What leads to it? The better understanding of the broader impact of crime. So we look a lot at recidivism and what are the causes in relation to crime. I'll talk about that a little bit more with a study that we've done. Support for those involved. So we also bring in the community of support. That's really important in a restorative justice conference to make sure that people are appropriately supported. So is it, you know, a support worker, a counselor, a police officer, a family member, a friend, whatever or whoever they need to be able to go through that process, we can bring in. And oftentimes we find, you know, especially with young people harmed, their parents have been equally impacted, or a partner has been equally impacted. They have the opportunity to be a part of the conference and talk to that person who has harmed their partner or their child and get their questions answered as well. It can be a very powerful part of the conference. So we bring in that community of support to help make sure that they understand what's happened and help them move forward as well. Another thing is we've reduced the caseloads for courts. I know that sounds like a funny thing to include, but we actually are very quick and efficient at restorative justice processes, and we can move things along and get them out of the courts rather quickly. So we also have done some research to show that if we get a pre-charge referral, so if we get to people really early, we can save the courts, for every $1 we spend, we save the courts $3. So it's not only good for the courts, it's good for the community, it's good for the taxpayer. Restorative justice is a cost-saving measure. We find that we have great feedback from our clients, so not just offenders, not just victims, their community of support, the police, the people who participate in our conferences give us excellent feedback. We'll show you some of that in just a moment. You heard Emma say we also have a great compliance rate. So people say they're going to do these things. 98% of people do the things they say they will in a restorative outcome. And we have some research specifically about our program that we did with the University of the Sunshine Coast to show that we can reduce recidivism. So for offenders or persons responsible going through our program, they are less likely to reoffend. And if they do reoffend, it's at a lower level. So we can see what the actual impact of recidivism is in our program in restorative justice, and it's been very positive. So lots of great outcomes for the community as well. So just a few bits of feedback directly from our clients, from our feedback forms. So this is from both victims, offenders, and their communities of support. You might notice a bit of a theme in the feedback. A lot of a chance to talk about the issues, a chance to sort things out, be able to tell their story, be able to be heard. So that's a really big piece of feedback that we get from clients. And it's extremely meaningful to a lot of people. I had a conference last Thursday for sexual assault, and it was really meaningful for that person harmed to be able to look at the person who harmed them and tell them, I'm not that person. I am a strong and powerful person. And they needed that opportunity to do that, which they would not have gotten through a criminal justice process in the courts.
Thanks, Casey. I'll skip this.
Yeah, I think, Penny, we're just going to skip through this one. We were going to check and see if people were listening, but hopefully everybody knows that restorative justice can accept any type of harm, and we can be very impactful, especially in high levels of harm. So on to eligibility. You're probably very excited about restorative justice at this point and thinking, what sort of matters can go to restorative justice? So at one point we did have some pretty strong criteria about what could come to our program, but we have dropped all of that. So it's fairly simple. We need an offense against a person which has caused some kind of harm. So we can't, for example, take charges on, drunk driving where no one's been harmed, or drug offenses. So we need people who have been harmed to make a referral, and the referral is received from a justice agency. So Queensland Police are our biggest referrer, DPP, any Department of Corrections, any justice agency can make a referral to our program from a person harmed. So you might have somebody who comes into the community legal center. If they're a person harmed and they're looking for a restorative justice process, you can support them to make a referral to our program. And formal agreement. If there's an agreement in place, we currently have one with Metro North Mental Health. They can send referrals through to restorative justice. We also need everybody to be available, so we need to be able to service the parties involved. We are now a statewide service, and we used we used Teams to be in contact with people. So we need to be able to get in touch with people, and it's voluntary, so we need everybody to consent to the referral. That is our eligibility, so it's fairly low in what can come to us. Our referrers, so Queensland Police and DPP, for example, have their own restrictions on what they think is appropriate to send to restorative justice, but from our end, these are the things that we're looking for.
Thanks, Casey. So as Casey's already said, we do accept referrals for all manner of things, and we talk about high risk matters. So this is that we do accept referrals for sexual and domestic violence offences, and also situations where a child is the person harmed. Excuse me. So the person responsible still needs to be an adult. It's really important with all of those sorts of matters that there are appropriate supports in place for the parties to be able to participate. For example, that they're engaged with counselling, there may need to be a domestic violence order in place, those sorts of things. I just want to say a bit more about domestic violence. Excuse me. So we're not doing restorative justice in relation to domestic violence orders, but we take referrals of domestic violence charges. We don't get very many referrals for intimate partner violence matters, but we can take them. We've already talked about our guiding principle of do no further harm in terms of participating in our process. With DV matters, we're obviously also doing that extra layer of risk and safety assessment in terms of the domestic violence dynamics. And we really do prefer that people actually have a domestic violence order in place, obviously with that exception to allow for participation in conferencing if it's a no contact order, and also for the person harmed particularly, but also ideally the person responsible to be linked in with relevant domestic violence or other support services. And for us as practitioners, that's partly about sharing the, I guess, load of responsibility for that risk and safety assessment as well. We're also really looking at the nature of the domestic violence. So the charge might relate to a particular incident, but we would get some of the backstory so we can make a more informed assessment around the dynamics of the domestic violence. So, for example, if it was clear that it was a coercive and control situation, it's highly unlikely that RJ is going to be suitable. So in terms of domestic violence matters, we most commonly get referrals for harm within broader family relationships. So, for example, between siblings or intergenerational harm, that might be in that elder abuse sort of space, or quite commonly actually between parents and children. And that's usually where a parent has been, say, charged with an assault, and they might view what they did as appropriate discipline of the child, but they've been charged and child safety is involved. And we really notice, particularly in these family contexts or where people are known to each other, that often the person harmed, it really matters to them that there is justice, that there is accountability, but they don't necessarily want the person who's harmed them to go through the criminal justice system. And these cases are also often about relational repair. Just give you a quick example. I had a case where there were two brothers, one assaulted the other and was charged. That brother was using ice at the time. And in discussion with the person harmed and his dad, it was clear that the main concern was the brother's drug use, and the brother who'd been assaulted no longer felt safe at home and was really worried about something like this happening again. So as an outcome of the process, the defendant agreed to engage in a drug and alcohol program over 6 months. But probably the most significant thing was that he just hadn't realised how unsafe his brother felt at home as a result of his actions and his drug use. So it was really important for that to be discussed in the conference and to give them the opportunity to also work on the relationships. With sexual matters, we also provide a psychoeducation session with persons responsible, and that really looks at what the law says about sexual offences, how these kinds of offences can impact victims, and goes into some detail about what affirmative consent requires. And we found these sessions are actually a fantastic opportunity to unpack in more detail with defendants what they did, and often really elicits much more insight and understanding and accountability. And we also hear, persons harmed are usually really pleased that the person's participated in the session because they've learned about consent, and it's really important that they're not going to do something like this again. So I'm just going to flick over this slide because Casey's already really talked to all of this. Casey.
So we're going to talk about what makes a matter suitable for restorative justice, or I guess not suitable for restorative justice. Actually, we're going to talk about what makes it suitable, and Emma's going to talk about what makes it not suitable. So you've heard us talk about we really need the consent of all parties to engage with restorative justice. One thing we are looking for is also similar enough stories. We don't want people saying, oh, no, that didn't happen, or I didn't do that. That wouldn't be okay in a conference, and we don't want to cause any further harm. If that's the case, they want to argue about what happened, it needs to go through a court process. The person responsible has to be accountable for their behavior, and you know, we look at a spectrum of accountability and try to work with them to increase that accountability. There needs to be enough harm for people to actually want to engage in restorative justice. If we have a victim business that's lost $100, they're unlikely to want to spend time working with us to repair the harm. So there has to be a significant enough level that people want restorative justice. The person responsible has to be willing to take action to repair the harm, and we need people to be ready. So sometimes they are not ready to talk about what happened. And if that's the case, we'll say, look, it's not suitable right now, but maybe you want to come back at a later time. So there are some different possibilities on how we could manage that.
Thanks, Casey. So what makes a matter unsuitable is pretty much the flip side of what Casey just said. And these points are here for you to read. Just in terms of a person responsible not being accountable, I guess, as Casey said, there's a spectrum of accountability, and it's about what the person harmed needs, what level of accountability they're looking for. But if the person responsible is, for example, significantly denying what they did, or engaging in victim blaming, or seeking to excuse their behaviour, then we know that it would be harmful, or would be most likely to be harmful for a person harmed to hear anything like that from them in a conference, because that would just add another layer of trauma. So, for example, I had a recent matter where a dad had assaulted his teenage daughter. His level of accountability in terms of what he'd done was fairly low. She wasn't looking for a lot from her dad, but she definitely wanted a genuine apology. And my co-convener and I worked with him quite a lot around growing his insight, taking responsibility, how she'd been affected by his anger. But ultimately, we were concerned talking to him that no matter how carefully we structured the conference with the two of them together, he just slipped too readily back into victim blaming. So we made an assessment that we could still proceed, but we would do that with the daughter providing a victim impact statement, which the convener, we then met with Dad anyway, and we went through the victim impact statement with him. That was very impactful, and gave him the opportunity to reflect on what he was hearing from his daughter in her own words. And then he has agreed to write a response to her, and she asked him to actually reflect on specific things in that response, which he's agreed to do. And that response will come back via us. So there's still that kind of extra layer of checking. If he's written anything in that response that we're concerned isn't going to land well with her, we'll do a bit more work with him on that response before it goes back to her. I think the only other one I want to comment on was just, again, that idea of voluntariness and participating freely. So again, another case example was a domestic violence matter. It was a recent separation, and the person responsible had actually assaulted his ex-wife's new partner. So the man who'd been assaulted was very fearful, but he was also fearful of retaliation if he didn't agree to go through the restorative justice process. So, and there were other factors, relevant factors as well, but ultimately we made an assessment that he couldn't participate freely. His consent was not freely given because of that fear. And so we said it was not suitable for conferencing. So just quickly looking at this, and I think you've really seen this in that video with Roman and Carmen as well, but just in terms of the overall process, referrals come into us. We do an initial check in terms of, is it eligible? Do we have any more information that we need? So for example, we might need to know about bowel conditions. Do they allow contact? Those sorts of things. Then the first thing we do is we contact the person harmed and the person responsible, and we do intakes with each of them separately. And those intakes can involve support people. So at that stage, really hearing from them about what happened, what the impacts have been, what might be needed to make things right, answering any questions, And sometimes there are multiple conversations or appointments needed at this stage. Once the person harmed is clear about what they need in terms of outcomes and making things right, then we do only a little bit of negotiation between the parties around that. And once there's clear agreement on that, and we've done that really thorough suitability assessment, then we look at actually moving to conference. So what we call a conference is basically a meeting where we bring people together to talk about what happened and the impacts and what they're going to do to repair the harm. What's agreed is then documented in what we call a restorative outcome plan. That's a very brief document, and that goes back to police prosecutions as well. And we then monitor compliance by the defendant with any agreed outcomes for up to 6 months. Once it's fully complied with, only then do we send the matter back to the referrer, and it's only at that stage that they would then look at potentially discontinuing charges.
So there's a couple possible outcomes. So there are a lot of outcomes, but we have some limits on what we can facilitate. These are the most common outcomes that we see through our process: a written or a verbal apology or statement of remorse, a commitment not to reoffend. So this isn't something that we can monitor, but it's often something that's written into a restorative outcome plan, that person is not going to repeat the behavior that got them into this situation. We do facilitate quite a bit of financial compensation, and we use the Victims of Crime Assistance Act of 2009, which is the one that Victims Assist Queensland uses for compensation. We use that as a guide about what is reasonable compensation. We also facilitate restitution. So if there have been damages to anything, in an assault, somebody's phone gets smashed or their glasses are broken, we would ask for receipts in relation to that, and we can facilitate those costs as well. And this is directly from the person responsible to the person harmed. So it can be quite powerful. Oftentimes people do ask for a donation to charity rather than money directly to them. And the most common outcome is counseling, and that can be for the person harmed or the person responsible. So the person responsible could pay for ongoing counseling that the person harmed has received, or the person harmed can say, look, I'd like you to do some specific counseling or a course in relation to your behavior, or something else meaningful to the parties. So we've had some really, out of the box things. The challenge is we can't always monitor those things, but we can get people to make good faith commitments to what they're going to do. I had one a couple years ago where a university student was asked to take a women's studies course. We couldn't monitor it, but it was a good faith agreement that this person was going to enroll in a women's studies course as a result of what they had done. So it can get very interesting, and it is about meaningful outcomes for the parties. Again, we use the guides from Victims Assist for our financial compensation, and we do ask for substantiation. So we do need receipts. We need to understand, the amount that's being requested, where that number comes from, so that we make sure that it's a reasonable request.
We're going to show a short 3-minute video, but I'm very conscious of time, and we did want to allow time for questions.
So maybe we save the video.
Yeah, can I just jump in? I don't think the video is going to work. I think we've got a sound problem
Yes.
from the speakers rather than the microphone. So it might be better if we just share that link with people afterwards, if that's okay. My apologies for that.
Okay. No, that's great. And I had forgotten about the sound issues because I was going to suggest that we skip this to allow more time for questions. And you really did see in the Roman and Carmen video a bit of an idea of what happens in a conference anyway. I suppose the most important thing with this is just that that conference, that meeting can happen in a number of different ways. So it can be directly involving the person harmed and the person responsible, either in person, over the phone, or via Teams, or it can be with the person harmed writing or recording a victim impact statement, or they can have someone else represent them in a conference. So like the parent of a child who's been harmed may represent them in the conference instead. So it's really, again, working with what's going to work best for the person harmed in terms of the format. And we also, in each case, actually plan the conference. For example, what's going to be discussed, in what order are things going to be discussed. So really tailored to what's going to work, what's needed in this case.
So just quickly, some stats. You've heard us talk about some of these really great things from our program throughout. So this is from 23-24. You can see most of the things that were sent to us were actually conferenced. We had some that were withdrawn, some people we couldn't get a hold of, and actually not that many were unsuitable. We really try to work with people to make things work. We do have a really high agreement rate, compliance rate, and satisfaction rate. And our numbers are continuing to grow as we get more traction statewide.
So how can you as community legal centres support people in or accessing restorative justice conferencing? So if you're working with a person harmed by crime, as we said, that person can make a self-referral and they just need to contact us directly. Our PowerPoint, our email and phone are on the last slide of this PowerPoint, and so we can just take a phone call or an email from someone. You can also encourage that person or support that person to speak with police or prosecutions about making a referral. If you're working with a person responsible for crime, then again, giving them information or supporting or encouraging them to request a referral through police or prosecutions. And lawyers have a really important role to play actually in preparing both parties for restorative justice. So certainly with a person responsible, working with them around taking responsibility, what they might need to do or have the willingness and capacity to do to repair harm, but also really giving people legal advice about what the court process could involve and look like, so that sometimes they're tossing up, which way would I rather go, giving people that information so that they can make a really informed decision about how to participate. We might actually just quickly show you this one. So this is the QR code. We would love you to quickly scan this code and then you can sign up with your email address. We send out occasional newsletters. We're not going to bombard you, but it's just a way of staying up to date with what we're doing and hearing a bit more. And might just leave that there while we take any questions that are in the chat.
Thanks, Casey and Emma. That was really, really interesting. And I did find that every time I thought of a question, you'd then answer it. So maybe that happens to our participants as well. We've had one question come through so far. This is from Narelle. Do you accept referrals out of the Seniors Legal and Support Service program, so around elder abuse? I think you did touch on that, but that's a specific area people would like to hear a bit more about.
Yes, we can accept referrals. You would need to support them to go through a justice agency, or you support them to make a voluntary referral to individual referral to us as a person harmed. We do see quite a bit of elderly clients in relation to fraud charges, especially within families, and they elect to go through restorative justice because they don't actually want to go through the justice system with a family member who has harmed them, but they do want to see that person be accountable and repair the harm. So that is quite a common referral that we see in restorative justice.
And that's pre-charge, obviously, because it's just self-referral.
Yep, it would be a pre-charge. Or if they are currently in the justice system, it would be about us supporting them to go to the referrer, the police, and say, hey, we would like to actually resolve this through restorative justice. Could you make a referral?
Okay, that's terrific. Thank you. Really helpful information, I'm sure, for everyone. The next question comes from Robert, who asks, what level of success have you had with domestic violence matters?
Good question. We go very slowly and very carefully with domestic violence matters. So we've been accepting them for a couple years now. We mostly see them in that family space rather than intimate partner, though that is actually increasing for us. and they have the same levels of success that our other cases do. So we would say that I would say the same as our pie chart that you saw, that about half of them would go to conference, and probably a quarter would be unsuitable. Those ones do take more time and a lot of preparation because we want to make sure that everybody is appropriately supported.
Great, thank you. The next question comes from Nicole. She's actually got two questions here. The first one is, how do you determine if an offender is genuine? And the second question is, how long does a typical process take?
Ooh, good questions. So I can answer the second question very quickly. Our goal is 65 days is our turnaround time. And we have been just crushing that recently. So most of our matters have been turned around in 65 days. It's really been a focus. So we do that quite quickly. If it's a complex matter, it's going to take longer. So just keep that in mind. So we aim for most of our matters within 65 days. The question about how do we know that somebody is accountable is a very difficult question. But we do a few things. We interview them, often multiple times, and in person, if at all possible. And we're assessing not only their language, we're assessing their body language, we're assessing actions, what are they going to do, how are they responding to questions. There's quite a few things. We also engage their support parties as well to check in about that person, you know, their accountability. We'll reach out to a lot of community of support to make sure that that person is actually engaging with our process and being truly accountable. Emma, you do this all the time. So do you have any other tips about assessing accountability?
I think it's everything Casey just said, but one thing that we do see too is sometimes if a person responsible comes into our process and since being charged, or certainly before coming to our process, they talk about what they've already learned, you know, how they've been impacted, and they've already been reflecting on their behaviour and what they learned. And sometimes they've already taken the steps of going, I really need help with my alcohol or whatever it is. So things like that, where the person has already done some reflecting and made some changes, you can see that they're pretty genuine in terms of both taking responsibility for what they did and also wanting to not do it again.
Yes, those are all things we have on a scale of accountability that we use. You know, are they low on the accountability scale, or are they high? Are they actually taking steps already to repair the harm before they've gotten to us? Those are some of the key things we look for.
That's so interesting. And I suppose one of the questions that's occurred to me as you've been presenting is that I was curious about the nature of the skills within your own team. So I assume it's a multidisciplinary team who is doing this work and working with you. And so I was just curious about what sort of skills you have in your teams.
Ooh, great question. We are all nationally accredited mediators because we are part of the dispute resolution branch. And I think we pull on those mediation skills quite a bit, but we do a lot of training actually. There's an additional level of training in relation to restorative justice skills, you know, how to question effectively, how to manage the balance of power, how to ensure that you're safely practicing with victims of crime. And then we do more training, especially in relation to sexual violence and domestic violence, to ensure that we're working safely in those spaces. So yeah, I think we start with mediation as our basis and build from there.
Right. Oh, that's really interesting. Thank you. And there was a question that came in from Renee that was essentially asking that same thing. So I wasn't the only one who was curious about that. So thank you for sharing. The last question that we've got, and probably we'll need to wrap it up there given the time, is related to where you've got people with disabilities who may be causing harm, and are there some particular ways of approaching that might be different or unique? Rather than, you know, dealing with people who are not experiencing disability.
I've got a case example that speaks really well to that actually. So it was a referral from the Child Protection Investigation Unit of a young man in his early 20s with an intellectual disability who had sexually assaulted his younger cousin. And the family was very close, and there'd been really significant kind of ripple effects of harm across those extended family relationships, as well as obviously for the little girl herself. And her parents were adamant that he should really understand the seriousness of what he'd done, which is why they wanted him to come through our process, but they didn't want him charged. They didn't see any value in him getting caught up in the criminal justice system. So working with him with an intellectual disability, we had a number of appointments with him. It was really important that his mum was involved in all of those appointments, and we actually spoke to her first and kind of said to her, what do we need to know that's going to help us to communicate with your son, to engage effectively with him? You know, you guide us in terms of that. And she was awesome. And then she was in each of those appointments with him and really supported him to kind of understand and to respond to things. So that was great. And then we also, we decided that we did want to ask him to do the sexual consent psychoeducation session, and our high-risk conveners run that. And Claire, who was going to run that, did some research and really kind of tweaked that session to just, I guess, make it a bit more probably easier for him to understand, so changing some of the language. But she actually found that he really got it, but she specifically went and looked for some like sort of simpler video clips and things like that that she could use just to make it easier for him to engage with that material. So that was really good. And the conference actually went really well. So yeah, but I guess at the end of the day, it's adapting our process to try and make the process as accessible as we possibly can for the person.
Yeah, that's right, isn't it? And I think that's a really, really powerful and illustrative example that you've used there, and really gives us a sense that the process is capable of being adapted and responding to where people are at. And I think that's really the key of it, isn't it? Is that you're actually, you know, responding to who's in front of you.
Yeah, we're dealing with people.
Yeah. Awesome. Well, that's the last of the questions, so we will leave it there given the time. So I just wanted to pass on a huge thank you, Casey and Emma, for your time and expertise in delivering an excellent webinar for us today. Thank you for coming down to our office and bearing with us through all of the technology ups and downs. A huge thanks to everyone who's joined the session today for your engagement and your participation. Apologies for the tech challenges. We'll ensure the link to the video is shared with all our participants. And yeah, just a reminder to complete the feedback survey that'll pop up on your screen once the webinar is closed. It does help us to improve our program over time. So I'm going to close it off there. Huge thanks again, Casey and Emma, and we'll look forward to hopefully seeing people at our next CLCQ webinar in early May. But for now, it's bye from us.